Welcome back to What I Missed TV. So I was rewatching a few videos of the YSL RICO trial, and I have caught prosecuting attorney Adriane Love in yet another lie. But this certain lie proves that there is no evidence in this case. It also states that they lied about having certain warrants and affidavits for some of the wiretap they have obtained because they never produced certain ones, specifically Ryan Boyer, and even gave up and stated that they will not be using it. Now, in this first video I'm going to play, Judge Whitaker asked the prosecuting attorney, Adriane Love, to show her warrants and affidavits. She seems confused and dumbfounded when she asks her that. Judge Whitaker ordered her to obtain the document. Mind you, they submitted the wiretaps back in the fall of 2023, but never submitted the warrant for the wiretaps. Brian Steele, who is Young Thug's lawyer, brings it to her attention about how all of a sudden she remembered to turn over the evidence a year later. This is a mess. Now let's take a look.
Which caused them to say, oh, this person looks like he's a part of this.
Okay.
And then looking at the number of times and the types of communication between them, they're able to see data exchanges. They were able to compare it to the time that we believe the murder occurred.
Okay.
And they were able to follow on the surveillance footage that we have the path of.
Okay. So, I mean, basically the raw data from which they reach these conclusions is all from the wiretap?
Yes, it's from the wiretaps. And then when they got the cell phones based on what they saw in the wiretaps and during their investigation. And I believe that as it relates to the Waters Road incident that occurred during that same time, they were able to, this is still information in the wiretap, but there was communication from Mr. Boyer about what was going on at the Waters Road incident. That's a part of the data that's included within the wire information.
Okay. Have you, meaning the DA's office or APD, conducted any interviews of Mr. Boyer?
No, not only no interviews, no warrants have been secured either at this time.
All right. I'd like to review the affidavits in support of seeking the contents of cell phone, or did you not need that because you had the wiretap stuff already?
We because no one had any contact with the person himself, we never had access to contents of his cell phone, just his cell phone.
Okay, so when we're saying cell records, it's essentially like location information.
Yes.
Okay. All right. So can you get me the affidavit in support of that, please, to review? Yes, sir, Mr. Sharp.
Your Honor, regarding the state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear.
Okay,
There's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case. And there was also, Mr. Harvey's also pointing out there was no raw data provided in the wiretap regarding the wiretap itself.
Okay, I guess when I said data, I meant the information from which they formed those conclusions.
I understand. We were aware of what numbers were calling what numbers.
You just weren't aware that whatever this number is was was connected. It's obviously somebody's, but y'all didn't know whose phone.
Correct.
It was.
And I can state in my place as an officer of the court, upon information and belief, that I've listened to pretty much all those calls. I don't recall in any calls in the wiretap where that number's involved, anyone ever saying any government name that would put us on notice and say, oh, that's DeMarco Boyer's number. So we've been pretty diligent.
Okay. So Ms. Love,
Yes.
what do you say about that?
I'm not refuting the person's name. I'm talking about the phone number whose records we turned over being present and the content of his conversations and communication.
Okay. So do you have the affidavit available?
That's what I'm getting.
Potentially by the time of the affidavit, but certainly by the time the cell records were secured in the fall of 2023, you knew that phone number was connected to DeMarco Boyer, true?
That is true.
Okay. So is there a way that the defense was supposed to have also known that that phone number was connected to DeMarco Boyer?
If the court will permit me 1 second.
Go ahead.
Will the court permit one of our team members to step outside of the courtroom and make a phone call to expedite this obtaining?
Yeah, absolutely. Unless you are the one who needs to step out and you're the one in the midst of the argument, the rest of your team can do whatever they want to do. Okay?
And Your Honor, just from memory,
Yeah.
I do know and believe that there's a reference to not his given name, not his formal name, but to a nickname. I'm getting that information.
In the wiretap?
Yes.
One other thing you were going to do, well, a couple of other things today. We discussed yesterday providing the exhibits to the extent they're currently ready with the rest of them. Has that been done?
Can I get that to you at lunch? She's still working on it.
Okay. Okay. And co-conspirator statements the same. Okay. All right. Any idea timing on this?
So our legal assistant is working on getting the affidavit.
Okay.
The nickname listed in the so the wiretap affidavit was served in discovery 2 on 8/22/2022.
Yeah.
So,
I'm not looking for the wiretap affidavit. I'm looking for the affidavit to get Mr. Boyer's cell records. I don't assume that was served in discovery, was it?
I'll check. Should not have been, because the reason that the phone records weren't served was that they were considering arresting him.
So the answer is no on that one.
Correct.
Two things, Your Honor. First, yesterday we were told
If you ask me,
that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
And I reached out to the investigator who got that last night. That person, I can provide information to the court and Mr. Sharp as to what is happening to the lady that on their end.
Is there some reason that can't just be shared right here and now?
They're trying to thwart a murder.
They're trying to do what?
Thwart a murder that is underway or being.
Okay, then seems they should pass off the responsibility for getting the affidavit to someone else.
My legal assistant is looking for the affidavit.
Did you in any way respond to Mr. Sharp?
No, I didn't see the affidavit email. What we were trying to get last night was the information about the phone records. That's where I got part of what I provided to the court this morning. What I'm waiting on is my legal assistant, because the person we were able to communicate with at the door said, the lead investigator said that the affidavit was provided to us. So
The affidavit was provided to us as in, I don't know what.
Turns out, I'm sorry.
Well, I mean, I would assume so.
So we have it, we should have it to give to Mr. Sharp and to the court. I'm awaiting that to provide it to the court, Mr. Sharp.
Okay, and so you didn't see the emailed request from Mr. Sharp last night that said, could we please have the affidavit in support of the cell record?
I did not, and the court is welcome, Mr. Sharp is welcome to look at my email.
I'm sure you get a lot of emails.
I did not see that. I don't even know what time he sent it, but I did not see it.
And I want to be very candid with the court. I sent this to Mr. Atkins because he was the one that sent the information.
Well, that's why you didn't see it, Ms. Love, because it wasn't sent to you. It was sent to someone else.
Because he was the one that sent us the phone records. And I want to be clear. And I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either. Obviously, I meant search warrant and affidavit, but I did put search warrant. But we haven't received either.
At what time did you send that? It was
1:53 p.m.
so yesterday afternoon. Okay. Okay. Okay, so I understand that I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent, and this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked the court yesterday to allow me time to speak with team members.
Right.
And the information internally that I know is that when the phone records were initially secured,
In the fall of 2023.
Yes, yes.
Okay.
When they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial,
Do you know when the decision, if there was one, was made, okay, we're not going to get a warrant for him after all?
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there is still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. That person wants a warrant. So there's not, the decision to obtain the warrant has not been abandoned. The
Okay.
efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And time progressed. It was in our possession.
Mm-hmm.
It occurred to team
You
members.
fumbling, Miss Love.
This is something.
Look how the judge
we can't
looking at
wait
her.
for
Like you was
a
full
warrant
of
for
shit.
arrest on. All of that is true. And I would have to consult with our team to see when they asked that those records be plotted, because at that point, I know that would be something that at least in our minds we're thinking, we could use this. So I could get that date as well, the date that they were sent over to be plotted. But,
Okay. Because, I mean, do you think that it's reasonable that at least by that point you should have shared that information with the defense?
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier, at least by then.
Mm-hmm.
So initially there was this belief and understanding that there was this investigation that would lead to an imminent additional person charged. That has not occurred. And there was the realization that we have in our possession this data that we need to turn over.
Are there any outstanding warrants for any other things for Mr. Boyer?
Yes, I believe he has, not here, I believe he has, I think he is in jail for a murder, but I think he is in jail in another county, not here, but I think he's in jail.
For like a pending murder? Not a pending murder. The murder has already happened, the murder that is he charged or is he just?
Charged, I believe he's charged for a murder.
Okay.
I have no details about that murder, I have no details about that.
Okay, but he is in custody somewhere in Georgia facing charges.
Yes, the capital.
So, does the state intend to try to talk to him?
We were not going to talk to him.
Okay. Does the state intend to use this plotted out, whatever y'all got about his cell phone location at different times?
Not unless, so no, not in the case.
All right. And all the information you, the state have regarding Mr. Boyer is inculpatory of these 6 defendants, or not all 6 of them, whomever is charged in the Thomas murder?
In drinks.
Drinks. Oh, okay. Oh, okay. Which is something that other than your opening, which isn't evidence. Have you gotten to that point in the evidence yet?
No, that would be likely the one of the last.
Okay. All right.
I feel like there was another question the court asked me that I did not answer.
I don't know what it was at this point. All right. So I will, whenever it's forthcoming sometime today, get and share, if I assume Miss Love's going to share based on the request, the affidavit in support of and the search warrant, and with the defense and also with the court, right? Okay. So we will await that. And then if anybody wants to argue anything concerning it, I will listen. The fact that this has to do with the drinks murder makes it a little less strike that. If y'all want to say anything else after we get those, then I will entertain it. Okay. All right. So in the meantime, let's keep plodding through this set of statements of Mr. Zachary's.
Can I ask a date or a date certain for the court to inquire of a date certain on this issue before you?
On the debt, on the getting the affidavit and the search warrant?
No, on, I'm just, I'm sad saying it. I'm really hurt saying this, but this is not new. So a date when Miss Love just said, "Oh, shoot," this is not a quote, but something effective. "Oh, shoot, we must turn this over." That was before giving it to Agent Bernie. So what happened on that date of the "oh, shoot" to we get it yesterday? And we don't get it with like, "Oh, this is new stuff. Let's
Good
talk
question.
about it."
So we are one team, but we have many members and parts. But I will get the date. But I can tell you that when I said that there was the realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out because it was not mine. It was not my realization.
Okay.
I'll find out. What I'm saying is,
who's in charge of the team?
I am. And so before
Okay.
it's mine, generally speaking, I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
All right. And you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Yes, this weekend we were talking about it and we turned it over.
All right. So sometime over the weekend is when the realization occurred. Oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over.
Oh my gosh, it has not been turned over and we need to turn it over.
Okay. And you're getting us the information about when we get the affidavit in support of the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense.
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. right? I mean, obviously not, since
No, because-
you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So,
Well-
we weren't thinking along those lines then.
Okay, had you at any point provided information that the phone number that y'all all know about from the affidavit and the nickname, which I think that's what it was, you were going to tell me what the nickname was, is actually DeMarco Boyer. Did you ever before Monday share that information?
No.
Okay. All right. What was the nickname?
Unk is
Unk.
the name that's listed on, I think in the wiretap, I think it's
Okay.
Unk. That's and I'm also seeing if there are any other nicknames associated with that number. There may be more than one. That's not uncommon. So I'm going to get all of them. May I step to the door once more?
Yeah, and let me, before you step to the door, is there at this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of? And you may want to huddle with whomever comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch. Okay. Can you do that? Okay. Yeah, just we'll recess in place until you come back from whatever you're going to find out at the door now.
Thank you. And since we're recessed in place, I'll just sit here.
Okay. Are there other objections encompassed within what you just said, Mr.
Right.
Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. You know, to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there was no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause, and it's all coming in as a conduit through some, quote, expert. And it comes through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been conducted?
For police reports, yes, we were actually. I think the court told us to do it for a specific act, and I can't recall which one it was, and we did. And there wasn't, but we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes,
And that
you
produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over, because what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no,
I'm
sorry.
sorry. Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes,
Yes.
we don't have anything extra. We will go back again, because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know,
Yes.
but then I ordered you to. So did you do it again?
Okay, so
Because I ordered you to.
we have not inquired a second time, and
I apologize to the court.
That
We're gonna
is-
do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Atkins, you could have done it.
Well,
Yes, Your Honor. I'll go make a phone call now.
So the following day, all of a sudden, Adriane Love decides to throw the Ryan Boyer wiretaps out. She said it very smoothly, in my opinion.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones, so this is inadmissible hearsay.
What are your thoughts? Do you think they paid attention to what she just did? Do you think someone is going to bring up that she didn't hand over the warrant and affidavit for Ryan Boyer wiretaps? Leave us a comment. Don't forget to hit the like button and subscribe to the channel for more content like this.